Yes.
My lord to my lady.
I see what we've done over lunch. We have, I think, all three read Mrs. Justice Lieber's decision in JZ, which is very full and useful background. I'm not sure ultimately it helps us then in the specific issues before us, but I now understand how it fits into the kinds of issues that were being debated. It also shows the origin, I think, of the in-principle consideration that was done in this case. It was the first time it had been done, wasn't it? The second thing that Lord Justice Lewis has done is looked again to find, if not the actual form that the declaration about the biometrics took at the relevant time, at least some evidence stating it or setting it out. He's been unable to find it, so we hope you've had better luck.
Yes, I think we have. We're just trying to collate the documents, but... Could we hand up? They're hole punched, but they're not put together yet, I'm afraid. Insert them.
Thank you.
And again, these are documents that derive from the JZ case. And the first document you have is a letter from Mishcon Durea dated the 10th of December, which explains the problem that JZ encountered when trying to fill in an online visa application form. And in particular, if you turn to the second page of that, at 1, 2 and 3, it explains the circularity of the form.
Oh, I see.
And annexed to that are screenshots of the relevant pages.
Sort of experience many of us have on online forms, but in much more serious circumstances.
Yes.
Yeah. Okay. Well, that's very clear. Thank you. But I see why the Lord wasn't able to find it, because I think because everybody in the case knew the background, nobody needed to spell it out.
No. And so my.
Yeah, I haven't seen this before.
And then as
And then I think the final document you have is the letter from Government Legal Department dated the 4th of February.
not the final, but we have that. Yes.
Yeah. Explaining that in the particular circumstances of the case, the Secretary of State was willing to treat JZ as if the efforts to submit the online form that he described, together with the screenshots of the form he had tried to complete and submit, had been successful, and the Secretary of State would go on to consider whether or not, in substance, to waive the...
well, it's defer is the important one,
sorry,
because I think,
defer.
like the claimants here, his position
Yes.
was, I'm happy to do it in Pakistan, but I'm not going to go to all the risk of going to Pakistan
Yes.
unless I know I can do it.
My Lord is, of course, completely right, and that's important. It was a deferral of the need to register biometrics prior to consideration of the application in substance. Right,
then you say that's all. We have also been given I imagine for completeness, although anything that falls from my lord is worth reading, his order in, well, I suppose logically order, Mr. Justice Kerr's decision to grant partial permission in JZ, and then
The decision of the Honourable Justice Lewis.
on PTA. Right, thank you very much.
So I hope that gives you an overview of how matters evolved in JZ.
Yeah, and more specifically, what the precise problem is about
Yes.
the biometric deferral box.
Or was, because of
Yes.
course it has now been
Quite
resolved
right.
on the form. So I'm not going to go back to the facts of the individual cases, save just to highlight 2 points. The first is that in S's case, the Secretary of State has never been able to find any record of an ARAP form actually having been submitted.
Yes. Now, what does one make of that? I mean, it doesn't matter if you're right on the principal point, but is the court? Are you advising the court to find that it, or not to find that it was submitted?
No, I don't think the court needs to do that. Our position is it was reasonable of the Secretary of State, having not been able to identify the form, whether that's because it wasn't successfully submitted or because it went awry in some way, to say, please submit a form, because that's the way these applications work.
Okay, hang on 1 second. Is there any evidence? I mean, we can ask Ms. Knight about this when we come to her, but is there any evidence in which she says in terms, I did submit a form and I see there's been a dispute about it, here are some particulars, I did it on my desk on
I don't
such and such a
recall having
date.
seen that, but I'm sure Ms. Knight will take you to it.
Yes, I haven't seen it.
We've
Okay.
got 2 pages of screenshots of parts of what looks like the ARAP.
Yes,
Yes.
at the very beginning of the clip
Yes.
we have, and that's all.
I'm sure those are genuine in the sense they're genuine screenshots, but it doesn't follow that it was submitted, but
No.
there may have been problems.
Yes.
Okay.
Which is
thank
why
you.
I invite the court simply to proceed on the basis that the Secretary of State was in a position where she could not identify an ARAP form or any visa application form, or any visa application form, I should say, probably in terms of emphasis. And it was reasonable of her to say, here is the process, please submit an application
Yeah.
form. In AZ, a form was submitted. You have that at pages 5 to 9 of the clip. And in both S and AZ, it was in April 2022, the 11th of April in S's case, page 73 of the clip, and the 13th of April in AZ's case, page 131 of the clip, that the broader point was raised that filling in a visa application form in any capacity, so visitor, human rights, joining family, would amount to a material misrepresentation and give rise to potential adverse consequences for the claimants, as they then were. What I'd like to move to, if I may, is why we say the judge at first instance erred in law.
Can I just ask one factual point, which puzzled me, probably isn't relevant, but I just don't like being uneasy about something. In S's case, following through the documents in the clip, the first one we've got is the 20th of September 2021, although it's clear from that document that there had actually been previous correspondence, which we haven't got. But I think we can live without that. Then there's more types of correspondence. There's the submission of the ARAP application. We have a GLD, the last document we have at 69 in the clip for a long time is 24th of November 2021, a GLD letter.
Yes.
There's then a 5-month gap, during which time Mishkons are replaced by Wilsons. And it seems some things have been happening, but was there literally no relevant correspondence or no correspondence in those 5 months? I don't quite know.
Okay. I think there's been an enormous amount of correspondence inter partes and between solicitors over the course of the proceedings.
Perhaps the answer is, and I'm sorry, I was doing this last night and having to work it all out. The answer may be well, no. I was about to say that during that time all correspondence was in the context of the proceedings, but the proceedings didn't start till the 11th of till the 14th of March. If there is no obvious explanation, we'll just leave it. But I mean, it was a surprise when all this was being presented as so urgent and so urgent. They'd all, on what we've got, went quiet for 4 months.
Yes. Well, Ms. Knight may want to deal with the interregnum. Could I just try and help with why we started with the 8th of October letter in S's case? And that's because if you turn to page 126 of the core bundle, this is the amended detailed statement of facts and grounds. You'll see at paragraph 4 that the case that was being put was that the application for leave to enter was made by online submission of an ARAP form on the 24th of September 2021, supplemented by letter dated 8th of October 2021. And similarly, in AZ's case, it's specified when the application is said to be made. There was liaison between the parties after the message from my Lord Justice Underhill's clerk, and I think it was by agreement that these were the documents that were provided.
Well, don't worry. I wasn't really
ones.
worried too much about that, but I just made some of the story a bit more different piece out.
Yeah.
But I take your point. Those are the two pleaded applications. Or two documents which together form the
application. And the relevance of the April correspondence is that that's where the point was raised for the first time, and there was evidence put in at the same time about how completing a different form would be a material misrepresentation.
Okay, thank you very much indeed. So let's come back to the facts. Or no, you'd finished with the facts, had you?
Yes, I was just going to move on to the judgment.
Yes.
I'm conscious of the fact the court sort of gave me 2:30 as a time to aim towards, so I will try and do this relatively briefly, if I may.
Yes.
We had some exchanges this morning before the short adjournment about the fact that there is no specific form for LOTR.
Yeah.
But of course, this wasn't a systemic challenge to the failure to have a specific form for LOTR. And that's probably, at least in part, an explanation for why there was no evidence explaining why the Secretary of State has decided to have the process that she has. The case that was being put was the submission of an ARAP form, supplemented by solicitor's correspondence, but materially the submission of an ARAP form complies with the policy this is the form for visa which most closely matches the claimant's circumstances. And if we pick up the judgment at page 108 of the core bundle, start probably at paragraph 129, the judge refers to the guidance, and then she says that there's an obvious reason why the LOTR policy directs that applications be made on the form for the visa type which most closely matches their circumstances. That's because any compelling compassionate circumstances will be decided by reference to the immigration rule which most closely matches their circumstances and the criteria in the rules which they're unable to meet. The visa route most closely matches their circumstances is ARAP, but their applications for LOTR using the ARAP online form have been rejected. The explanation given is that ARAP is not principally an immigration policy. Applications initially screened by officials from MOD who are best placed to identify who worked for or within. The UK government in Afghanistan, LOTR decision for the SSHD. It would delay the MOD in dealing with valid ARAP applications if they had to filter out LOTR applications, refer them to the Home Office. Therefore, the claimants are advised to apply via standard online visa routes, for example, for those seeking to visit, study or work or join family members. Paragraph 131, the online visa
Just pausing
routes...
there, hang on one second. Is that the first sentence? I agree with the claimant's submission there is an obvious reason. Yes, I see. Because again, that's rather inconsistent with the case as now being put. But it was consistent with the case then being put because it would explain why it must be ARAP.
Yes.
Yeah.
But we'll go on to this because the judge comes back to this, but we say that's simply wrong as a matter of principle, that the Secretary of State has always got to consider all the relevant factors and material circumstances that an individual wants to rely upon. And the selection of form used doesn't constrain or in any way sort of absolve the Secretary of State from doing so. And if you remember when we looked at the LOTR guidance in the first place, it sort of gave examples of the sorts of circumstances. It might be a family tragedy. It may be a whole variety of things. It may be for a short period, it may be for a longer period, but it's got to be considered on the merits and in substance. And if and to the extent that the claimant's case here was, it was really unfortunate that we were not evacuated during Operation Pitting through no fault of our own. Our circumstances, that you have seen how the argument developed, were all of those arguments can be put forward and the Secretary of State needs to consider them. And it'll be judged according to the lawfulness of her consideration, irrespective of the form used, is the first point we make. At paragraph 131, probably key to the judge's reasoning, which is, maybe it's right to say if they made, well, it's not. The online visa routes do not remotely match the claimant's circumstances. If they made false entries on such forms, they would be exposed to the risk of permanent refusal of entry on mandatory grounds and even criminal prosecution. Any attempt to enter the UK on false pretences in order to apply for asylum would be illegal. In my judgment, it's irrational to put law-abiding legal professionals in a position where they have to falsify their applications for the sake of their own and their family's safety. The relevant reasoning continues into 132. The options suggested by the government legal department, namely that they enter not applicable in answer to questions on the form.
Where did When did that suggest? I haven't found that suggestion in the correspondence anywhere.
No, it's in the witness statement of
see.
Janet Gordon-Smith.
Don't worry, I can find it. Thank you.
We'll give you a page reference.
Yeah.
But what she was saying was they could just enter not applicable to boxes that ask for information that isn't relevant to their basis of bond income, and then use the box, the other information box, to explain the basis upon which they seek leave to enter outside the rules. So the learned judge thought that was misleading by omission and carried the clear and grave risk that their LOTR applications would be considered and dismissed without any meaningful reference to the criteria which the Secretary of State applied in other comparable cases in the exceptional circumstances pertaining in Afghanistan. This is procedurally unfair. So that sort of reels back round to the first point, that your circumstances will only be considered against the framework of the particular visa form that you've used. It's the middle bit of that reasoning that we particularly take issue with. And the respondent's skeleton argument suggests that we have never disputed that this would be a criminal offence or a material misrepresentation. With respect, that's not been our position. Our position from the outset has been that this complaint about it would be misleading and render them open to adverse consequences in the future is totally unrealistic. And if I could just refer you to our skeleton at first instance, we don't need to go to it, but it's at page 303 of the core bundle. It's addressed primarily by reference to KBL because it was KBL.
So which page do you say?
303, paragraph 76.
Yeah.
Where we say it's addressed, as I say, primarily in the context of KBL, who was the claimant who fell out of the picture on the first day of the hearing. We say KBL, and now it appears all three claimants, goes so far as to claim that applying on the visa application form for any of the other routes would be tantamount to false representation. This argument and the concerns are without merit. There could be no doubt about KBL's or any of the claimants' reasons for seeking entry, regardless of the particular visa application form they used, and no realistic prospect that the Secretary of State would treat them as having made false representations. You've seen what we say in our skeleton argument about that. I know the Court's really well versed in all of this, very familiar with it from Balajigari, for example. We've included in the authorities bundle at the end the guidance. I don't know if you had a chance to see that, but it summarises the case law, I think, accurately.
Which page are we looking at?
It's at the last tab of the authorities bundle, starting at page 346.
Yes, we don't have tabs, but pages is fine.
I'm so sorry.
Are we discriminated against, by the way? Counsel get tabs, but judges don't?
I didn't get a tab, I've tabbed
Oh, right,
myself.
well, then we're in the same position. Anyway, 346, yeah.
346, and the substance of it starts at 349. So first of all, about in terms of deception, you'll see the second paragraph. Guidance also covers where there's deception by the applicant and the mandatory ground of refusal applies. This requires you to be satisfied there's been a deliberate intention to deceive by the applicant. And then picking it up at page 351. A short summary of some of the key case law.
Yes,
Just next to the bottom hole punch, dishonesty or deception is needed. Then a reference to Balajigari, the recognition of dishonesty as a touchstone. And then again, Leupan at the bottom of the page, dishonesty or deception on the part of some person is an essential prerequisite to mandatory refusal. The reality of this case is that nobody was suggesting that these claimants should do anything that could conceivably be taken to amount to
Well,
deception.
you're asking them to apply for a visitor's visa. You're asking them to say, I'm coming for a visit to the United Kingdom. You're asking for lots of information about earnings and dates of arrival and departure. And the reality is, they don't want to come on a visit to the United Kingdom. They say they're desperate, they're frightened, and they want to come and live here. So you're asking them to start in a framework when they're asking for something they don't want. Ignore all the relevant boxes, and there's a little box at the end that's got additional information, and you do that because you want a number and our biometrics that they can't comply with. That's the reality, really.
Well, I wouldn't entirely accept that,
No.
because they can enter into the form, as we saw, I hope, before the short adjournment. I am using this form because the guidance tells me to use the closest applicable form. I do not have a family member in the United Kingdom, or I don't
want to
intend
make a
come
visit to the United Kingdom. I want to come and live there.
Yes.
I mean, speaking for myself, not possibly for my lord and my lady, I'm subject to any reason, nightly say, unimpressed by the idea that they're having to lie, because, as you say, they can make the position perfectly clear, and it's vanishingly unlikely that anyone would say they'd suffer any ill consequences at all from having done exactly what they were told to do. But I am still deeply unimpressed by the argument that this is an appropriate, or might even be said rational, way to give claimants an opportunity which they're entitled to have at law to make an application, to make them go through a thoroughly inappropriate form, try and choose between a series of thoroughly inappropriate forms to ask them all sorts of irrelevant questions, merely so that they can get a biometrics arrangement and get onto the computer. I can't understand it at all.
No. I mean, as I think I said this morning, I can see why the court would be troubled about that. And I think probably the best answer I can give is that not being faced with a systems challenge and not being asked to provide evidence to justify or to defend a challenge to the system itself, but responding to a much narrower point in the context of a case raising some huge issues, the Secretary of State did not put in evidence explaining what her rationale was for the use one of the available visa applications.
Does it come to this? Just suppose we were to find that the refusal was unlawful for either or both, but one will do, I think, from the claimant's point of view, of the reasons given by the judge. Let us say that even if she had used one of these forms, there would be an insuperable problem about the biometrics box. You are warning us off considering, in the context of this appeal, the broader question, the broader underlying question, which is going to have to be answered sooner or later, I suspect. But you say not here, because this is not ever really how the case has been put.
No, that's precisely the position. And it would be a huge systemic challenge. It would affect cases way beyond the context of Afghanistan.
Yeah. Okay, I've got the point. You may persuade us to, if this situation arises, to not decide that point. You might have a harder struggle to persuade us not to say something which the Secretary of State might want to think about on this point.
No. I'm not going to try and persuade you not to say something that will give the Secretary of State food for thought, but I do say with considerable emphasis that my client is at least entitled to a proper opportunity to respond to a systems challenge before the entire system is found to be irrational.
We need to be careful about that. Systems challenges have become very fashionable, and usually the Secretary doesn't like them because they always say, well, no, you've got to look at the facts of the case. It is open to one individual to say, what has been done to me is irrational. If it affects other cases, because similar facts apply, then so be it. And this claimant does say quite clearly at 148 that she is challenging the decision on grounds of irrationality. In this context, the SSHD acted unlawfully or irrationally in declining to consider or determine the claims case outside the rules for the reasons given or at all. And then it goes on to deal, one, with the fact that there wasn't an application form, and two, that you had the biometrics. So I accept it's not the whole system is irrational, but she doesn't have to say that. An individual is not required to prove that the whole government is acting irrationally. Just has to prove that it's irrational in her case.
Well, what you have to say, I think, just following up on that, is I agree. The term systems challenge is pejorative. If the reason why it's irrational in her case means the whole system is irrational, tough. But I thought you were making a slightly different point, which is that the challenge, properly understood, was to not allowing the ARAP form to be treated as an application on the closest available. We'll have to look quite carefully at the pleadings. Either you or Ms. Knight may have to help us about that, but the feel I've got is that that is correct. But the problem is that underlying it is the question, well, what if you're wrong about, what if you're right about that, that the ARAP form wasn't a visa application form at all. Certainly by the time the case in front of the judge, the argument about whether the other forms were appropriate was very live. Well, I suppose it was live in the context of showing that they were less appropriate than the ARAP form.
Yes, precisely. And I mean, the pleadings are very long and were amended and re-amended. But for example, at page 179, it's put on the basis, this is paragraph 29, respectfully submitted that on a plain reading of the LOTR policy and an assessment of the claimant's circumstances, it's clear that the ARAP application, and for the avoidance of doubt, the detailed representations, including an invitation to consider the application under the LOTR policy, amounted to a valid and policy-compliant application for LOTR.
Where are you reading from?
I'm reading from page 179, paragraph 29, and this is AZ's detailed statement of facts and grounds.
What paragraph?
Paragraph 29.
Yes, I see.
What about the paragraph that I drew your attention to, 148, page 148, paragraph 50, and following? It's not put in quite the same way that it's put now, but Miss S was saying, what you're doing is irrational. You should be considering it, even though I haven't done what you want, which is to put in an application form.
Yeah, I think I would need just a few minutes to try and read that through in context of everything else.
Nobody doubts that they were saying ARAP was the right form, but they're also saying if it's wrong, then the system is irrational.
Well,
At least Miss S was, I think.
could I? So sorry, could I just take a moment? But I read paragraph 50 as being a precursor to paragraphs 51, 52.
Well, they've got to be read together. M51 says really that it's wrong to refuse to exercise discretion on the grounds there is no formal application, i.e. the formal application that's really required to be made, and it's wrong or irrational to force somebody to have biometrics when they can't, which is the two points that seem to arise now, although they're framed differently, I accept, and as often happens, but it's not right to say the pleadings, is it? don't have them there.
Well, certainly we didn't understand the challenge to be that the Secretary of State ought to have provided a specific form for use for all LOTR applications, and that the failure to do so is irrational.
No, I suppose what they were saying there was, this seems to be a fair summary. ARAP did, if your policy can only be made reasonable by ARAP being acceptable. If that wasn't acceptable, you ought to have accepted our letter.
Yes.
One way and another, we clearly made an application. And that necessarily means, inherent in that is the proposition that none of the forms, it wasn't rational to require insistence on any of the forms. So that second limb, namely you should have accepted our letter, doesn't that necessarily involve saying that the requirement of a form was irrational?
Not in the abstract, because very specific reasons were given for this. So firstly, there was the problem with the biometric tick
Well,
boxes.
that's different again, yeah. So that seems to be treated as a separate point.
It does, yes. I think probably because it had been resolved in advance of the hearing, and the wider point about it's requiring applicants to expose themselves to the risk of prosecution or mandatory refusal or refusal in the future on grounds of deception to use one of these forms. Therefore, the ARAP form ought to be accepted.
And looking at paragraph 81 at page 217, which is your grounds of defence, you appear to have understood the claim to be in precisely these terms. Although the SSHD has a discretion as to the grant of note and the waiver of biometrics, she is entitled to specify a process for applicants to follow. It is lawful and reasonable to require such requests to be made using an online application form, which allocates a reference number to the application. You do seem to be saying at 81 on 217.
Yeah, thank you.
That looks awfully like.
Well, again, we're going to have to study this, and but what it boils down to, your submission really boils down to, cut it whichever way you like. There was not a sufficiently clear case that it was irrational, as a freestanding case, that it was irrational to insist on the use of inappropriate forms. For this to be an appropriate vehicle for deciding that point, because you would say, for understandable reasons, it's not ever really addressed in the evidence.
Yes.
Okay. Right. Well, again, we've slightly diverted you from where you were, but I think helpfully, you want to go back to where you were, or perhaps you're there.
I think I am there, really, that there was no realistic prospect of the claimants being prosecuted or penalised in circumstances where they had been given very clear guidance, indeed starting from the LOTR guidance itself, which says just use the form that seems closest to your circumstances, through to assurances in correspondence and the Secretary of State's repeatedly stated position in litigation, which is that this is the way to apply for LOTR. It was quite unrealistic to suggest that they would be penalised for doing precisely that. It was also said in our skeleton argument that we have not been able to find any example in the 5 years plus that the current LOTR policy has been in force of anybody being penalised, the point being taken against them.
Perhaps because they didn't apply, because they were afraid. We just don't know, do we? And that tells us nothing.
No.
It's a debating point, I think. The rest of your submissions have been so clear and cogent, I don't think you would want to finish with that point.
Well, I will sit down at this point then.
No, you won't, because you're being handed a point from behind.
very much. I had asked Ms. Masood just to remind me of the page references where we could see the substantive ARAP decision. In S's case, it's at page 63 of the clip and the following pages.
I don't mean to be dismiss Masood's efforts, but why do we need to know this?
I just wanted you to see, when we were talking about the administrative difficulty and the delay that would be caused to ARAP eligibility cases proper by a system that encourages people who are seeking LOTR to apply via an ARAP form.
We'll look.
Because
Clip,
it's
clip
quite,
63.
Yeah. And in AZ's case, it's in the supplementary bundle at 183 and following.
Oh yeah, we've seen this, yes.
Yeah.
Yeah.
So just there does have to be quite careful substantive consideration of anybody who puts in an ARAP form saying I am eligible under the ARAP scheme.
Okay.
And the AZ one is 183 of the supplementary bundle.
Thank you. Unless my lord or my lady have any points for you. Yes, Miss Knight. Well, I won't repeat what I've said. I think it will be, I hope it will be apparent that we are, at least now, I think, on top of the facts, and are on top of the arguments that you wish to make. It doesn't mean you shouldn't make them, but we put a lot of them to Ms. Giovanetti, so you can make your submissions sharper, knowing that you don't have to start from scratch.
I just wanted to deal with the last point first in relation to why this is or is not a systems challenge and why we're here today. Remember the opening where we said it's an academic claim. Ms. Giovanetti's submissions were, well, it affects lots of other cases, and she said it was a systems challenge and we said it wasn't. So the Secretary of State has always had our claim, and she knows there's been a group of other claims, JZ being one, KBL being another, various other claims which have been travelling together, were case managed by Mr. Justice Swift at one point in a group of similar claims, and so it does come as some surprise to us that the Secretary of State feels taken by surprise by this process point, and that all the detailed evidence she submitted from Mr. Hall, Miss Eloise Gordon and Mr. Gregg about the operation of LOTR and ARAP and the process point comes as a surprise to her when, and we've got Miss Gordon-Smith's evidence, but that is the Secretary of State's evidence. It was foreshadowed by, you've been given Mr. Justice Carr's permission judgment, where he identifies that this is the workaround lawful. Mr. Justice Fordham made the same.
But the workaround is, I think we want to be careful here. Yeah. There's a point about the biometrics box that had to be ticked, and the workaround was directed to that.
I accept, yes.
That point is not what we're concerned with. I mean, let's be frank about this. You could win, and I don't say you will, you could win simply by saying that it was irrational on the judge's para 135. Was it 136?
Yes.
That it's all very well for the Secretary of State to say you could use one of her online forms, but that wouldn't. But that would have required her to make him or her to make a statement about whether you needed biometrics, which would have been untrue. Or you could win on that, and we could all go home. And you might or might not also win on the ARAP point. Yeah. That would probably have consequences for a small cohort who made their claims in the right time. Yeah. It would leave untouched the question whether the more general question of whether you should use these, have to use one of these inappropriate forms at all. But the judge didn't decide it on that basis. she decided it. She made some observations about that. That's quite true, but she decided it on two very specific bases. One, the ARAP form was appropriate. Two, the one we've just been over about biometrics. So, without being too fussy about this, and but simply for ease of analysis, it should really be you raising respondents' notice, saying, well, even if the judge was wrong about those, or we would also want you to decide on the more general point, which the judge didn't decide it on. And I'm saying that not to criticise you for not putting a respondent's notice, but just to say analytically, it's not quite the point the judge decided, although I think we can guess which way she would have decided it. Well, I say that, but I think it's what underlies her hint about saying, okay, you may think you've solved the problem by version 2 of the guidance saying that you can't use the ARAP form, but actually, I doubt if you would, essentially because you still got to use it in an appropriate form. So I'm sorry, that little speech was just meant to direct you to the point that it's that we have got to decide if we find for you on one or both of the other points, whether we need to go further or whether this is an appropriate case in which to go further. And I think what Ms. Giovanetti is saying, part of the reason it isn't, is that this point's never really been focused on. And you're saying, well, if it hasn't been, it should have been.
Well, my lord, yes, we did consider whether we needed to raise a respondent's notice, but we were very careful to focus on the order that the judge made in relation to what was granted, what was dismissed, which was dismissed the decision under ARAP, to reject the decision under ARAP, and to recognise that the Secretary of State's failure to treat the ARAP application in the alternatives as an application to LOTR was irrational in these particular circumstances. And so
we say you were keen to focus on the judge's reasoning. I mean, does that follow that you are content to win on one or both of the judge's reasons?
Well, we don't simply wish to win on the biometric point. We want to win on the fact that in the context of Afghanistan, in the context of which these particular claims and this cohort, small if it is, was considered, was that they all made ARAP applications, which is an Afghan-specific context, which so for therefore the LOTR has to be considered against the background of the role that the applicants undertook, the contribution, vulnerability, and the nexus to the UK. And I will take my lord and my lady in a moment to the most recent decision letters, because it shows where the system has gone wrong, completely wrong, and the way that Mrs. Justice Laing had identified and anticipated. If the decision maker does not consider the application for LOTR as in line with the ARAP application, even where a person does not meet the criteria. So it's not just confined to the biometrics and the misrepresentation. It is, we do seek to uphold that for these claimants, the appropriate remedy, the appropriate is for the court to find that it was irrational, and for the court to uphold the finding rather that it was irrational for the Secretary of State to decline to consider the ARAP applications in the alternative.
Yeah, well,
and that is the way that we put the case to the court below, and that's the way we put the claim in our grounds, we say. And so we don't seek to win on the narrow basis. But Mrs. Justice Laing was very careful. You can see it in her order. She gave a ruling on costs. She gave a ruling on permission to appeal. She's very careful to say, I can't give a further ruling on whether the decisions under LOTR were right or wrong, because there's not been a decision because of.
No, but that's a different point.
Yes, but what we seek to I didn't identify that we needed a respondent's notice to uphold the finding. We say that the closest form was the ARAP application.
No. Okay, well, perhaps in a sense, I may be exploring whether you're saying something you're clearly not saying. After all, you were saying the case didn't need to go ahead.
Because we were content with the judgment below.
Yes, but the judgment below, I think I'm right in saying, you must say if I've got this wrong. Basically was One, because ARAP was a visa application form. That's para 133. Ought to be. It was irrational not to. It was irrational not to treat it as one.
Well, ARAP was not. She says that it is in the immigration rules. So actually, very carefully, we put the case to.
Yes, no, but I'm just trying to see. Just.
Sorry.
But that's clearly the reasoning behind 133. It is irrational not to treat the ARAP application as an application.
Yes.
And two, separately, starting 135, were also unable to proceed because of the biometrics point.
Yeah.
And she says that was irrational as well. That's 136 halfway through. Those are the two bases. And if you win on either of those, the decision falls to be quashed.
That's right.
She doesn't say the whole system of requiring you to apply on an inappropriate form is irrational. Although she hints that she thinks it would be, because if you look at 134, she says this policy is at risk of a future legal challenge. That's to say, if you do exclude ARAP, say you've got nowhere to go, then it would probably be, or it might be.
That's the amended policy she's discussing.
Yes, exactly,
So,
exactly. No, of course, that's the point.
Yeah.
Because once you've amended the policy, then you can't avoid the bigger question of whether asking someone to apply on an inappropriate form is irrational.
But the way we put our case, sorry to interrupt.
No. So I'm in a sense I'm thinking aloud, but I'm trying to analyse what we need to decide if we're going to uphold her decision.
Yeah.
What? Don't mean we start by wanting to uphold her decision. How do we get there? What I mean is what would be the appropriate basis of upholding her decision?
Yes.
And it would be one or both of those reasons.
Yes. But
We certainly don't have to decide the wider question. And indeed, anything we said about it would be obiter, wouldn't it?
It would be obiter, but it might be, as the other obiter comments of Mrs. Justice Laing up below are, useful and important context for those who come after us and maybe ourselves who come after this case. Given that myself and my colleagues are involved, as is Miss.
No, well, I mean, and of course, Lady Justice Andrews wanted this to come up because she thought it might help in the other cases.
Yes.
And in a limited sense, even if we decided it on the narrow basis that I've been putting to you, it would help in the other cases, assuming the circumstances of all or most of them are the same.
Yes, I mean they
but
are.
The bigger question wouldn't be answered.
Can I just confirm what we say the bigger question is, just so I've got it clear? The bigger question that any application for LOTR.
What I mean by the bigger question, I'll do it as it were at dictation speed, and so everyone can say I got it wrong. What I understand the bigger question to be is it irrational of the Secretary of State to require an application for LOTR to be made by an admittedly inappropriate form out of the suite of forms that she regards as a VAF. And that's assuming the biometrics problem is solved. That is what I mean by the bigger question, which is something that's going to have to be decided sooner or later, I suspect.
Well, it may have to be decided sooner or later, but it doesn't have to be decided in this case because we are confined to the context of ARAP.
Yeah.
And this is and the way in which ARAP was operated during Operation Pitting and after Operation Pitting, and the Afghan specific context. So we are not concerned with what somebody who's applying from Syria to come to the UK as a dependent relative who might not quite meet the requirements of the adult dependent relative rules, or the child refugee route that Miss Giovanetti gave that example of. We're not concerned with that. We're concerned with how these two judges, S and AZ, can have made and considered by the Secretary of State in a timely fashion their valid application for ARAP, which was considered and rejected, as well as consideration for leave outside the rules, which is contextualised by what happened to a number of other judges who were similarly situated, which is why we argued the inconsistency.
Well, thank you. I think, speaking for myself, it's me who's raised this because I just want to know really what we ought to be grappling with, what we ought to be grappling with in our judgment. And I think I understand your position. I'll let you go back to the points you were going to make.
So, my Lord, that's the reason we say that we want to uphold Mrs. Justice Lang's judgment on those points, and in addition to the obiter comments of the obiter comments, is because we put it to her that it was irrational of the Secretary of State, in light of the way she had operated, she was able to operate and consider applications by judges who were similarly situated under ARAP, and we have JZ as an example for who, we'll come on to look at just very briefly how the immigration rules operated. Judges were granted leave to remain under ARAP who were supposedly working alongside or in partnership with the UK, when they themselves had no knowledge of the said partnership. They were just deemed to have been working in partnership. That's the Secretary of State's evidence in JZ's case, for example, which we can give you, which we can hand up in addition to what's been handed up so far. If that is the case, then the ARAP criteria are not hard and fast. They are flexible, and that they carry over, that flexibility carries over into leave outside the rules, as it did during Operation Pitting for a number of other judges, and we identified those comparators. Mrs. Justice Lang identified that herself, that although the pitting criteria were no longer in operation, she identifies that the factors in, this is at 126, the factors such as their role in promoting the rule of law and the risks to their safety arising from their work as judges, back to nexus to the UK, we say, particularly here, will still be relevant in any assessment of their cases. And so that's why we seek to uphold the judgment for these two judges. Any other judges who are similarly situated, or indeed any other persons who apply under ARAP who are similarly situated, may seek to get the benefit of a judgment. We don't go for a systems-wide challenge on how the Secretary of State should operate LOTR. What we say is how it was operated here.
But how do you deal? I mean, the first question is what the application form means in version 1 of the guidance. And I had thought, in my innocence, because I hadn't seen all the documents, that application form must mean the ARAP application form, because it's got application form written on it. But what Ms. Giovanetti says is, no, that's like the screening interview you have in asylum, and the visa form is a later form, and you could never have had access to that, because unless you do an ARAP and get accepted on ARAP, you don't get sent the visa form. And she's told us that the hyperlinks go through to various forms, but not itself. The ARAP document, to avoid calling it a form, is not an application form.
On the Secretary of State's case, as I understand it, all entry routes to the UK are in the rules, save for at the discretion. Mm-hmm. All of those entry routes, one can apply for discretion outside of that rule, except for ARAP. So if you're applying as a spouse, there's maybe discretion as to maintenance accommodation. If you're applying as an adult dependent relative, the nature and degree of that relationship. She put the rule, ARAP, into the immigration rules, and we looked at those rules earlier, including the fact that there are not only who you're employed by, an MOD, but special cases. And this is why the special cases are particularly important, because you don't have to have been employed by the UK government or anyone or a department of the UK government. You just simply had to be working alongside, and that has an elastic definition in the application, as we have seen in, for example, the JZ disclosure, which it probably is useful for the court to see. So it's not just interpreters or persons who are drivers or cooks or so on. It is, in the judge's context, the Secretary of State has now given us certainly, and we didn't seek it in the, as my Lord can see, and my Lord and Lady can see, in the before Mrs. Justice Lang, we didn't seek the disclosure at that point because we were trying to get these cases expedited and concluded, having been issued as long ago as November in S's case. So we were trying to say, clearly, ARAP, it's impossible for a person who's applying under ARAP to know whether they will or will not fit the criteria, because there's a criteria called special cases. which the judges, 13 judges, as we now know, were relocated to the UK on that basis. And we now know even more that not only were they relocated to the UK, but the criteria...
I think you're getting off the point, aren't you?
Well, my lords, the reason we say that is because if the criteria were hard and fast, then you'd have an application process. You'd say, right, I can apply under this because I know I'm an interpreter and I know I was employed. If you don't know whether you're going to win or lose under that, then there has to be, and was expressly sought, and we reference the case of Bihari and our skeleton argument, and the courts accept that. If we apply, we say we also want discretionary consideration if you consider we don't meet the requirements. The next question is, how should that process be undertaken? And there is a visa application form, it's just one that's not made public. So it's the only scenario where there's not a public application form.
Well, it's not the only one, the football one
Sorry,
too.
the
There are a number where they've got visa forms, but they don't let you have them to fill them in.
That's correct. And so what those two examples show is that there is discretion. It is the Secretary of State's either operation under the rules, ARAP E 276 BB1 4E, sorry, it's quite convoluted, or for example, in the case of the Afghan football team, the Secretary, that's Eloise Gordon's evidence in the bundle, we don't need in the supplementary bundle 1, which is we did exercise discretion outside the rules, and in order to process that, we used this form. But these claimants are in exactly the same position as the Syrian football team. The Afghan football team. They seek to enter under the rules on a discretionary basis if they fail under a different criteria or if there is no rule for them. And the Secretary of State says there is a form, but it's not public. And then in this case, is using that position against the claimants. That cannot be rational in the context.
Yes, but does it go to rationality either because the only appropriate forms are not ones that are made available, either it's rational not to depart from the guidance and treat the known wish of the two judges to come to the United Kingdom, whether or not they qualify under ARAP, or it's irrational to insist that they use the closest form when they can't have access to it because they're not allowed.
Well, it's certainly irrational to use...
But why is it the closest form? Can we look at it again?
With the form we've just been given.
Yes. I've gone and lost it. We put it in.
It's at the end of the second supplementary bundle, page 135, I think.
Is this the 135? Is that what I have it at? Is it?
Yeah, that's the one.
The point we make is it's unfair to require us to use the closest form is this one, but it's something we can't access, so that's procedurally unfair.
In many ways, it's an inappropriate form because it doesn't even have a box to say what your case is.
Extra information does on the second.
Oh, I see. Yes, it does. Yes, I see. Nope, sorry.
Yes.
Bad point.
So it's called, the type of visa application on page 1 is Afghan locally employed staff ex gratia scheme, and Mrs. Giovanetti advised that there was a similar form for ARAP. So the evidence before Mrs. Justice Laing was that this form was filled in by the MOD. That's Eloise. That's Mrs.
Well, no, they send a secure link and the applicant fills it in.
Well, that's
but the
the
applicant
evidence
will
for
not
today.
get it. She can't go on the website.
That's
She's
right.
got to go through ARAP, pre-screening. If she gets through the pre-screening,
Yes.
then she gets sent a secure link, as I understood, Ms. Giovanni.
Yes.
Yeah.
What happens
And
now?
so, it's not an LOTR application. It only exists if you get through if you're being sent to the UK under ARAP. So there's nothing in this form that will allow consideration for the exercise of discretion. It's inaccessible, and even if we could access it on the face of it, well, unless extra information is the way in which it could operate, there's nothing to demonstrate how discretion would be exercised. And the reason we say that bites or is prejudicial to the claimant is because if they can't put their case, there's no opportunity to put it, then you get, which is the point Mrs. Justice Laing was making, then you get a decision maker who then considers an application for LOTR without reference to any of the sort of ARAP or...
Well, hang on. Why does it make any difference? These are all inappropriate forms, including the ARAP one.
Yes.
The answer, yes, they're all inappropriate, but you can put everything you want in the extra information box. And if you say, well, they won't read the extra information box, they won't read it under the ARAP one either. So, what's the point?
There's not so much. So, the first point in relation to a form that's not this one that we've just been given, which is not publicly available, and therefore no applicant could fill it in unless they were given it, which is why we say there is. Mrs. Justice Laing looked at that. So it's not for us to design what the system could be, but one option could be that for ARAP, for cases that fail under ARAP, they could then be asked to complete a form if they've indicated they want such consideration, which is what these claimants did.
And the extra information would say something like the following: I know I do not qualify under the ARAP scheme for these reasons. However, I'm close enough to it, and my circumstances are close enough to it. I was an active female judge putting men into prison in Afghanistan, and I'm being targeted. For goodness sake, help me. I was on your side for 20 years, and I deserve to be helped. That's what she was put in.
Fair consideration. That's what Mrs. Justice Laing said. It would be. Mrs. Justice Laing said that there would be a risk of it not being considered, and that's. But
my point is that if you're right about that, if she's right about that, that would be true at this form as well. What? If those words that my lord put to you were put in the extra information box on any form, visit visa, let's just say visit visa, family visa, student visa, or if it was made available to them, ARAP visa, one would hope it will be read, but it would be no more likely to be read on one than on the other.
My lord, we're not suggesting it wouldn't be read, we're suggesting it wouldn't be properly considered, and that was...
right, but why wouldn't it be properly considered?
Because Mrs. Justice Lang's reasoning was that she says that paragraph 132, there's a clear and grave risk the second sentence on the bottom of the page, that the LOTR applications will be considered and dismissed without meaningful reference to the criteria.
Yes, but I don't know why she says that.
She says that because the decision maker has to be. We don't know that the Secretary of State has particular departments for ARAP and for judges or for family members or for students, but let's assume that would be logical, that there would be.
Oh, I see. So it would be farmed off to somebody who only does student stuff and say, "What's all this about Afghanistan?" and puts it to one side.
If I can just take my lord's.
Okay, now I get the point.
But perhaps I don't need to take you to the text of the letter, but I would invite the court to read the decision letter in S and AZ, the 22nd of July letter.
But that is clearly done by somebody who is an Afghan specialist.
Well, that is clearly done by somebody who doesn't make any meaningful reference to.
Yeah, but that's the point against you, isn't it?
Well, my lord.
If you say this is a bad decision, the point you were making before was, which I do now, you explained it, I understand, that if you do it on a student visa form, it'll probably go to the student visa office in Darlington or somewhere, where they don't know anything about the Afghan background and may not realise that this is the way it has to be done. Will think this is all very. But then you say, and to reinforce that, look at what happened in this case. But what happened in this case is he didn't go to the student office in Darlington. It went to the Afghan specialists.
But in this case, the one thing I would say is that the person considered that the closest route, paragraph 10, was for an asylum.
Which page are we looking at?
Oh, sorry, it's in the clip.
Yes, but which page?
Sorry, I've taken it out.
I think it's page 40 for...
Yes, it's 40 and 46. So I was looking at 46 for the purpose of S.
Okay, I have page 46. Yes, where are you referring us to?
So that was 46. So I just haven't, mine aren't numbered in the same way. It's a paragraph 10. I've taken into account the immigration, any sections of the immigration rules which we considered as appropriate. And I've considered that the closest applicable route, as S and her accompanying relatives haven't provided any information as having family members, haven't reasonably been able to consider their application to any other parts of the rules. And then the decision maker refers to temporary protection and asylum. And so she then says,
well, look, these decisions aren't.
they're not under challenge, but they demonstrate the problem with them going to somebody who not considered them against the closest route. That's the problem with this decision.
But I don't think we can assume the point that you're making that that's because the forms misdirect them, because it's actually the Joint Afghan Casework Unit. I don't want to say anything about these letters, but it may well be that they're deliberately straining a gut not to mention Afghanistan, just in case the decision would be irrational, because there isn't any difference. We just don't know.
We say that not referring it against the ARAP criteria, which are the special, what we now know about special cases and judges working alongside, it does lead to the risk that Mrs. Justice Laing identified. But we don't. If that decision, as it's currently may be under challenge, but isn't currently before the court in any other context other than for information, then perhaps that doesn't take us much further. But what we do say is that we seek to uphold the judgment below, where Mrs. Justice Laing identifies that the reason, the impact on the claimants of having a decision that doesn't allow them the process of, so paragraph 131, the online visa routes do not remotely match the claimant's circumstances. It talks about the false entries, and there is, where even if they're not exposed to actual prosecution, there is a risk of, when set against the purpose of the immigration rules, sort of Padfield structure, which is Secretary of State, as we say in the authorities, note in the authorities bundle, has statutory provisions for persons who make false representations, statutory provisions for persons who use deception, immigration rules that support that. She wouldn't design an immigration system for this cohort, which would invite them to make representations that are incorrect, even if they're not legally false, so to speak. All judges, if they've made an application to this country and they have to make an application to another country, they will be required to say, have you ever made a false statement in a visa application? It is a false statement, ultimately, and that would, whether that ultimately be found in a question of law as to whether it's false, the judges know that they have written something in a form on invitation of the UK government, or only after, only at a time. Those assurances were not given at the time of the decisions. They were only given in correspondence.
So the false statement would be what? I'm applying for a visit visa.
Yes.
Okay. I just wanted to be.
Yes,
clear
a false, incorrect for the purpose of. It's incorrect to say I'm applying for a visit visa.
But suppose in the box they say I'm not applying for a visit visa. I'm only using this form as I've been told to use the nearest one. That's not a false statement, is it?
It's the application form itself, the context.
Well, let's look at the application form. Remind me where it is.
The
121 in the.
Thank you, I've got it. Yes.
bundle.
Thank you. Let's just take this one. I won't do this too laboriously, we'll be here forever. But starting on page 121, or box, I think it is 121. Email address you can give.
Is it supplementary one before?
They've got to say at the very top, this is,
Well, right, you've got to give your name. That you needn't lie about that. Unique application number, I don't know, that's presumably generated later. GWF number, I don't know what that is, but passport number you can give, country of nationality you can give, date of birth you can give, gender, date of application, type of visa application, visitor visa. I'm not sure that's a statement, or it's no more than you're filling in the visitor visa form.
That's not. So I understand it, my lord. That's not something that you complete. That's what the form is.
Yes, quite exactly.
Yes. So
service option, duration of visa, don't know. That may all be generated for you, but if not, none of that would be untruthful. These are the bits you fill in, your email address. What's the main reason for your visit? You would put to get away from Afghanistan. Will you be then you can answer these questions. They're a bit silly, but you could answer them. what's the main reason for your holiday visit? You might want to put not holiday, let's see above.
And are these free text boxes? In other words, do they expand to accommodate whatever you type into the box?
I'm afraid I don't know that they all are free text boxes, but there is a concern that it says, give at the bottom of the page 121, give them details of the main purpose of your visit and anything more.
Yeah, well, you would say, my purpose is to live here until it's safe for me to go back to Afghanistan. Date you plan to arrive, date you plan to leave.
If on an ordinary visa application form, the date you plan to leave is obviously visit visas are time limited. And what the important thing about the ARAP application is they're not time.
No, forget ARAP applications. I'm talking about a LOTR application.
Yes.
Such as your client is making and being asked to make on this form. I haven't so far come across something that you would have to lie about.
Well, you have to indicate the date you want to leave the UK.
Well, you put indefinite.
Well, that's literally a contradiction of the visit visa rules.
I know, it's because you're applying on an inappropriate form. Look,
You're
you're putting at an open door that this is an inappropriate form. You don't have to persuade me of that. But I'm concerned with the case has been put much higher, which is that you're going to have to lie. So that's what I'm trying to find.
My lord, when will you have to leave? As I'm instructed, is that you have to add a date at that point. So you have to say when you.
Well, why can't you put indefinite?
Because the form won't allow that.
How do you know that?
My solicitors, those are my solicitors are trying.
Where's the evidence? Is this one thing Miss Terenius says?
Is that in the witness statement?
Is it in her witness statement?
We had the witness evidence of Mr. Raines and Mr. Golden. I think it's Mr. Raines.
Well, don't let's waste time on it now. Tell me, if you would have to put in a date,
Yes.
then you're getting closer to the kind of point to make. Let's I don't want to spend all the rest of this, but this all this looks all right. I won't have to lie here. Don't think you'll have to lie on page 3 of 10. Sorry, they're blanked out, so I can't see what the actual numbers are. I'm just going through. It's a big thing to say that you're having to lie and expose yourself to prosecution. Let's suppose that you're right. Ms. Terenius remembers rightly that you can't put in indefinite on date of birth. You had to put in a date. You could put in a date 30 years hence, presumably, but still rather awkward. When it comes to extra information, and you say, I'm filling in this inappropriate form because that's government policy that I must. I am not applying for a visit visa. And that means in particular that my answer about the date I intend to leave is put in simply because the form required me to put in a date. It is not in fact the date I intend to leave. And then goes on to put in all the rest about Afghanistan and the real circumstances why they're applying. Where's the lie? Where's the risk of prosecution? Where's the false statement? The one thing that might be a lie has been explained elsewhere in the form.
Well, we say that it's inherently in a visit visa application. However, the Secretary of State wants to suggest it is the closest thing that matches the claimant's circumstances. It does not, and if you apply for something that doesn't remotely match.
Ms. Knight, you know the question I was asking you.
Yes.
Why don't you answer it?
Apologies.
Sorry, that's rather.
No, apologies.
No, I should apologise. That was very rude of me. But I'm just keen to press you because I think it is important, not on whether this is inappropriate, because it's clearly inappropriate. You're putting an open door about that. Does it go further than being inappropriate and mean you have to lie? Now we've only got this one as an example. The moment I haven't quite seen how you have to lie.
No, we say is that it's a misrepresentation in the context of the overall scheme of immigration rules and applications.
Yeah.
Aside from I'm here for a 6-month visit and I'm entering on this date and leaving on that date, I intend to leave and go back to my country of origin. Aside from those things which are inherent in a visit visa application, which are set in the immigration rules as a statement of policy and presented to Parliament, aside from all those things, I can't demonstrate something that's...
No, well, that's fine. You're not
right.
giving away too much, because I, as you will have gathered, I am with you on this being a very odd system and very inappropriate. But I just don't want to exaggerate the inappropriateness unless I'm shown that it really makes you say something which clearly isn't true, which was certainly the case about the
Biometrics.
biometrics.
Yes. No, I mean, the way we put it in our skeleton argument, perhaps I can take 2 points and then perhaps we'll leave those, which is that we refer to the case of Thebo at paragraph 28 of our skeleton argument. Now that I think about it, apologies, I think Thebo is not in the bundle. But if I can just...
Well, I don't even know what case.
If I can just... so we refer to...
Let's go to your... Let me just go to your certain argument. Yes. Which paragraph?
Paragraph 28 of Thebo talks about the residual discretion. But I realise that, sorry, the case of Thebo, the point I wanted to make about Thebo is in the case of Thebo, but not in the skeleton. I wonder if I could just hand up the authority. Or I could just read the passage, which is simply about the form, which is what it says on the form, with reference to somebody who was seeking entry for one purpose but didn't qualify, is your application will be automatically refused and you may be banned from coming to the UK for 10 years if you use a false document, lie, or withhold relevant information. You may also be banned if you've breached immigration laws in the UK. So that it supports the argument that we're looking at the suitability guidance. There are statements in relation to not making incorrect or inaccurate
But is any of this in the context of following the instructions given in the guidance about making applications for leave to remain outside the rules? And that guidance says you must use a form that doesn't precisely match your circumstances or is wildly inappropriate because there isn't a form for applying for a...
Yes, I mean, my lady, Miss Giovanetti said it was patently inappropriate. I think that's the phrase. In some cases, the form may quite closely match someone's circumstances. So that wouldn't be a misrepresentation if you're saying I'm applying as an adult dependent relative, but I'm...
Well, it still would be a misrepresentation in just the same way as you're saying this is. It just wouldn't be. It would be less of a misrepresentation.
Well, if
to
I'm
say
64, an adult dependent relative needs to be 65, if I remember correctly, one would make those representations in support.
But you wouldn't be applying for this type of leave to remain outside the rules because the guidance makes clear that this type of leave to remain outside the rules is for a very narrow category, and if you're applying for something that is based on Article 8, you should use other routes.
Oh yes,
perhaps it's close to Article 8.
Or perhaps an alternative example would be for somebody who is applying as a visitor, but one of the rules for visitors is that you can't work whilst you're a visitor, paid or unpaid. And so an example might be somebody who is applying to come and care for a short period of time. So they're not going to visit because they're not doing what visitors do, but they will be using the visitor application because it does closely match their circumstances, albeit that they can't comply with one of the requirements of the rules, which is not to work, paid or unpaid. But in this scenario, we're quite far away, in fact, very far away. And there is, I think in my submission, we can't just say, because in some scenarios, the form that most closely matches your circumstances isn't necessarily a false representation. That in this scenario, for a judge who wants to flee Afghanistan, is not trying to get a visa to claim asylum, but wants to flee Afghanistan because they say the UK they have a nexus, the work that they undertook alongside the UK, or in support of the UK mission, which is, again, as you see from Mrs. Justice Lang's contextual analysis of ARAP and LOTR, what is really going on there. It is very far removed for that person to say, I want to come for a visit to the UK, and that's consistent with the structure and purpose of the immigration rule, when actually the structure and purpose of the immigration rule which they are most closely aligned to, is the one thing the Secretary of State has put into the rules, which is ARAP. That's why we say it's not a one-size-fits-all submission, which is why we're not taking a systems point. This is really about this narrow cohort, and that is why.
Well, I suppose you could put it like this, actually. Given that there is a rule for people coming from Afghanistan where there is some nexus, not to allow them even to have access to the form, where they could say, I don't strictly meet this because it wasn't actually the UK, it was the US I was working for, but it's similar in substance. You might want to say that that's irrational, that the one form that does appear closer, because you're not coming for a visit with the implication therefore that you're going to go away again. You're not coming to join a family, you're coming because you're an Afghan person who's been involved in those kind of activities, and now a different government has taken over. And you might want to say it's irrational to keep the one form off the website.
That's why we focus it narrowly rather than broadly. It's why it's not a systems point, it's about this cohort. It is because in this context, as Mrs. Justice Laing was at pains to set out, having heard 2 days of evidence, and when she delved very deeply into what was the purpose of the ARAP, looking at the evolution of the guidance, why did the categories expand to include working alongside, how that was interpreted, what pitting LOTR was and how it was operated in process and in substance terms. She went through all of that with Mr. Hall's evidence to say, so it isn't just a comparable any old LOTR application for something that's unjustifiably harsh. When we look at the criteria in the LOTR policy, look at the way it was operated under pitting, that's where we get the irrationality in the sort of Johnson sense. And I know both my lords are very familiar with that case. It's in the bundle at tab 15. Don't necessarily need to go there, but why the rationality of the system when one assesses it in terms of the impact on this cohort, which is why it's ARAP specific, ARAP and LOTR specific, and when particularly examined against the context of judges who worked alongside. They're not refugees. This has nothing to do with trying to get a visa to claim asylum. It's because the risk arises on account of that work and its nexus to the UK mission. That's what Mrs. Justice Laing found, having heard the evidence, albeit her findings don't directly go to the question that we're concerned with here, because as she says, I didn't make that order because we didn't have an LOTR decision. But in all other ways, if we are correct in terms of our entitlement to decision, and if we do go on to challenge the decision that has now been made, how that will be challenged is with reference to those kinds of principles. And so,
what you're saying is the government has recognised there is a specific thing to do with Afghanistan, yes, because we invaded there and we were there for 20 years to achieve certain things. In the rules, we've got a cut-off point. If you've achieved a certain level of involvement with the British forces, you get it automatically.
yes.
If you're just short of that, but you're doing the same sort of things, you say, well, perhaps we're close enough, even though we haven't quite crossed the rules, to get in. And that's why you say it's the most closest set of circumstances.
Indeed, it's a very particular and peculiar and a very unusual set of context. And it's an evaluative question, which means it could be evaluated as an ARAP, or it could be evaluated on special cases.
It's the degree of integration into British mission aims in Afghanistan,
yes,
and you cross the threshold because you actually were working for the British Air Force Base in wherever it was, Kabul,
yes, or conducting anti-terror trials, or having the UK members of the UK embassy coming to watch those trials. We'll give you the JZ material because it does indicate how the operation of ARAP functioned in the
but that's why you say it's the closest form, and the closest form you can't get in through ARAP, and you can't get in through making the form, using the form itself, because it's the one form they don't put on the website.
Yes, and we put a note into the government. Mrs. Justice Laing asked for a note on what was the role of the UK in Afghanistan. It's at page 114 of supplementary bundle 2. She asked what was the goal, and they put in documents to support the mission in Afghanistan. And that's the context, which is wholly unusual to probably any other immigration rule. Although there is obviously structure to those rules, the context and the narrowness of the context is what we emphasise here, about the UK supporting the rule of law and the supporting, in particular, anti-terror activities, including supporting judges. Although that that comes from Mr. Hall and Mr. Gregg's written statement, I think, rather than from this particular note. But it was about what was if the ARAP rules and the guidance are framed in how did the individual support the UK mission and the contribution and the nexus that comes from with reference to the note. But we don't necessarily have to go back to the note because Mrs. Justice Laing made that all very clear in her judgment.
Now, is that what you need to say about the question of whether ARAP is the closest available form?
Just bear with me. Thank you, my lord. That's what we see on that, in respect of that being the closest form.
Sorry, just a tiny technical point. You are leading for both teams, is that right?
I'm leading for S, and Miss Savage is leading for AZ.
Right.
We've had sort of a division of labour.
Sorry, so I've been rather rudely assuming, because you're the only one in the front row, which is correct, because you're the only Silge, that we'll only be hearing from you. Are we also hearing from Miss Savage?
I don't think so. No, thank you, my lord.
Another time, Miss Savage.
I'm grateful.
But so in that sense, she's adopting your submissions. Yes. But you're not, just so I get the formalities right, you're not instructed for AZ.
No, that's how we presented it before Mrs. Justice Laing. We did division. Miss Savage presented one of the issues, but that's now.
Okay, that's fine.
Allocated our labour.
Sorry to interrupt about that. And just one other small point while I'm on pure formalities. I meant to raise these at lunchtime and I forgot. The Secretary of State for Defence is still a party to this appeal.
Yes.
But the interveners aren't?
The interveners were the family members of S.
Oh, I see. I've got that wrong. I assumed the interveners were the other judges, but they weren't.
No, it's simply the family members of S, I think, and the family members of AZ.
I haven't looked at the appellant's notice, but are they nominated as parties?
They
someone sort this out later. Someone let us know. It's simply, if we're going to do a judgment, we want to know what to put in the title.
Indeed.
But the Secretary of State for Defence is a party still.
That's correct.
Although realistically, now that the ARAP bit has fallen away, it's really, that's right, isn't it, Ms. Giovanetti? It's really all the interest of the Home Secretary now, isn't it?
Yes.
Because LOTR is a Home Secretary business, ARAP is a joint business.
That's right.
Yes.
It's failing so far as it impinges on the MOD's ability to administer the ARAP scheme, but the decision, the LOTR decision, is firmly a Secretary of State for the Home Department decision.
I keep seeing references to the Foreign Office ringing up and saying we've got 6 more we'd like to bring in, please. I haven't quite understood what the Foreign Office is doing.
They're not a party anyway.
They're
not a party. Oh, I don't need to worry about them.
They were a party because they managed were managing, also integral to managing the ACRS resettlement scheme.
Oh, right, okay.
Yeah. And of course, pitting LOTR, the
They did
evacuation.
operation. Yes,
Yeah.
they do.
Okay, I'm sorry. It seems sensible to deal with those while I remember them on a natural break. Going back to substance, where are you going next?
My lord.
Or maybe.
I think I dealt with the new decisions, which doesn't necessarily take us very far. We've dealt with the, just coming back to, so we say, just in the principal point we make is that there was no, the single ground of appeal was that Mrs. Justice Laing was wrong in her judgment to reach the conclusion that she did, that it was procedurally unfair or irrational for the Secretary of State to require the defendants to treat those applications as LOTR. In my submission, the Secretary of State hasn't, in the submission she's made today or in her skeleton argument, identified that Mrs. Justice Laing was wrong and that she failed to take into account material evidence that was before her. We've set out in our skeleton.
Part of the problem is that some of the material evidence wasn't before her.
Yes, but she wasn't. The evidence that she took into account the evidence before her as filed by the defendant, and she reached the conclusion on that evidence. That was the evidence.
So your point is she was entitled to do that because that was what she.
That was how it was put to her.
Yeah.
And if the Secretary of State is now saying, "Oh well, we have other evidence that we didn't put before her," that's not a ground of appeal. There's no application to admit any further evidence.
I didn't hear you objecting though when we were saying all this. Maybe you were just being constructive. We don't like we don't like counsel who over object.
No, I mean,
It's a bit odd that now that we have a better understanding of what has happened, we shouldn't be deciding the case on the basis. It's not exactly fresh evidence. It's just a clearer documentary picture of the process, which is described in rather summary form in the evidence. But seeing that new visa application form clearly means we have to think about it slightly more carefully than the judge was able to do.
I mean, the judge did have. She invited this. We had pre and post hearing submissions and invitations from the judge, not uninvited submissions. Invited. She asked the Secretary of State to provide a visa application form that had been used for the Afghan football team, for example, and it was disclosed. You've got the note.
Yeah, I've seen all that. Yeah.
Too, as to that being a visa application form that wasn't publicly available, demonstrated that discretion could be exercised in a particular way. So it's now being said, or we have the same sort of form that we use for in the ARAP, in successful ARAP cases, but not in unsuccessful ARAP cases. It is just quite. That case didn't come, although we sought expedition, just for the purpose of the court's note. We applied in lodged her claim in 29th of November 2021, and she was refused permission on the papers. And then there was another.
I don't think it would be helpful.
The point is that there was a long lead-in time to the hearing for Mrs. Justice Laing. The Secretary of State had plenty of opportunity to put forward whatever evidence she wanted to put forward, and there's nothing on the face of the grounds to demonstrate that she erred in law.
Yes, no, I've noted that.
For this court, in its appellate capacity, that is of importance.
No, quite. No, I dropped that point. You make it very fully in your
This isn't an appeal on the point of law, so the question really is, I mean, did she either err in law, or was she wrong in the evaluation of the material she had before her?
And so we're asking for. We put our case we were asking for in our skeleton argument in before Mrs. Justice Laing. Sorry, apologies. We asked. Yes, we did ask for paragraph 1, 2. Paragraph 12 of our skeleton before this court. We said at 12b, so we say that at the bottom of 12, that if ARAP is not an application for entry clearance, it's entirely unclear on the evidence which VAF should be completed by the MOD or Secretary of State's Home Department, and even less clear which form should be completed by an applicant who's assessed as eligible.
But that's now been resolved. We now know, don't we?
But we know
whether you call it probably is a VAF, but it's not a publicly available VAF.
No, so and we do say that I mean that evidence is before the court now, and the court it may be useful if the court is proceeding on the basis that if this claim is proceeding on the basis it's academic, then the court can admit whatever evidence it likes and say what it likes on the basis that it's it won't affect these claimants or these appellants. But
if it's academic, we shouldn't be saying anything, should we?
Well, if it's academic, but the court decides to proceed anyway.
Yeah, we use academic in two different senses.
Yes.
It's academic for these claimants'
It's
cases,
academic for these
but
claimants,
not academic for other cases.
If it's academic for these claimants, but the court wants to go on to consider it and then say, actually, we now know what the evidence is or should be, then that's.
But you're right. We do have a certain amount of
constraint.
Again, don't read anything into this, but if we find for you on a narrow or limited point, we've got a bit more flexibility where, if we think it helpful and legitimate, to admit further material, which might be unfair if we were going to find against you on it.
Yeah. I mean, what we do, just coming back to what we say about the scope of the appeal in our skeleton argument, the Secretary of State's case was a recipe for chaos. I didn't see any recipe for chaos in the way we put our case or the thing that we sought. We filled in application forms which were publicly available, which is the ARAP form, supported by competent, coherent representations by solicitors who support in support of LOTR and the alternative, when there wasn't a publicly available alternative form that closely matched the claimant's circumstances.
And which you could not have used in any event because they would have turned it down because you couldn't fill in the biometric section, don't forget.
Indeed. So that's the recipe for chaos point is not made out by what we've heard today. If there any recipe for chaos, is the Secretary of State saying to anybody and everybody, apply on whatever form you feel like, because I'll look at it whatever happens, as long as it's not an ARAP form, when that's the situation that most closely matches your circumstances. So back to our narrow focus, we are two judges where we know judges have been granted under ARAP despite the way in which one looks at the ARAP guidance. When we've got the disclosure that we now have, which emanates from the Secretary of State, which was disclosed belatedly on the duty of candour, according to Mrs. Justice Hill in her judgment. But in any event, it demonstrates that some judges do qualify, and this under ARAP, and some do not. Some were granted under pitting LOTR, some were not. And Mr. Hall's evidence is, in summary terms, that just being a judge isn't enough to qualify under ARAP, but it might be. But how would a judge know that? Particularly when the partnership point isn't one that's even necessarily known to them, viz. Judge W and others. So it's not a recipe for chaos. The form isn't publicly available. Here's the visa route that most closely matches the circumstances. And that's why we say that these claimants have suffered a detriment. The impact on them has been significant delay while we argue for 6-9 months about what's the appropriate form. We've only just got a decision from something that was made back in September and October. So, in fact, we invite the court to strongly uphold, even with, notwithstanding what is the correct form that's now available. We ask the court to uphold Mrs. Justice Lang's judgment. And we identify at paragraph 39 of the skeleton what the threshold is. This court knows it very well, but it's cautious for a start, and findings of fact were they properly supported by evidence? Yes. Were they ones that the judge could reasonably reach? Yes. And there's no proper basis to reverse them. What you are really doing, if the court's so minded, is to admit the evidence and to tell, as a matter of guidance, what forms are available and how the system does in fact work. So the Secretary of State was the one who relied on Johnson to say that the irrationality threshold hadn't been met. That's in her skeleton argument, and we say, properly looking at Johnson, which was my lord is very familiar with, that when we look at the relevant criteria, including how it's operated and the impact on the claimants, that for those reasons that we can show that Mrs. Justice Lang was correct in her analysis, which was I'm just looking at the different parts of the rationality test of what's alleged to be. This is looking at Johnson. My lord doesn't have to turn it up, but the questions posed by Lady Justice Rose, as she then was, were what's the alleged to be irrational, and then what are the perverse consequences of that regime, and then finally she says the potential impact on others of the scheme, and sorry, finally, just the final point was, is it irrational not to have a solution for the problem?
Yeah.
The size of the cohort, the arbitrary nature, the duration.
All right,
of the
that was all in the very different.
So yes, my lord.
Thank you very much. Sorry if I'm
No,
interpreting
not
body language correctly. Any, Monsieur Vanetti?
Very briefly, if I may. Firstly, it would be a mistake to proceed on the basis that the issue in this case relates to judges in Afghanistan. Cases that are going through the administrative court and are stayed or are behind these cases include journalists, human rights activists. There are large volumes of people we all know who are still in Afghanistan, or like us, fortunate enough to have made it across to Pakistan, but who say our role, our activities were broadly in line with the UK mission. we were acting in a context where our work was valuable in promoting education, women's rights, the rule of law, free press. So it's really dangerous to proceed on the basis that we're only concerned here with a narrow cohort of judges. They're quite close to ARAP, so why shouldn't they be allowed to apply using
This is more,
an
if I
ARAP
may say
fee?
so, this is more a substance point.
It is a substance point.
And we're not
But
on
it's
substance.
just repeatedly been said in me, these judges are very close to ARAP cases, but we're not, there's no limiting feature that restricts the ratio to judges. That's not really what this case is about at all.
And in fact, it doesn't matter because they weren't judges who were Arab judges. They weren't
They
judges
weren't
working
Arab
on the
judges.
British basis.
That's absolutely right. I think that's the next point I was going to
sorry,
make.
I'm so sorry.
It is- no, not at all. But that we're now a little bit clearer about who ARAP covers and who it doesn't cover in the light of a whole series of decisions, including Mr Justice Kerr, my Lord's refusal of permission to be, and it is fairly specific and narrow. There will, of course, be cases where one of the online available forms is closer to an individual circumstances, and cases where it's much harder to find one of the available online forms which appears to be appropriate. I'm not going to repeat my submissions about it not being necessary to engage in deception, and that if you make it absolutely clear on the form, this is why we're using this form, or why I am using this form, because the guidance tells me to use the one that appears the closest, and none of them are very close, but this seems the closest to me. I am seeking leave outside the rules in the exercise of discretion. I am in compelling, exceptional circumstances, and here is my case in the additional information box. Nobody looking at an application like that in the round, which is what one would have to do, of course, could suggest that that was deceptive or materially misleading in any respect, we'd say. In terms of the process for the consideration of ARAP claims, it's quite right that there wasn't a form before Mrs Justice Laing, but the process was explained in the witness statement of Janet Gordon-Smith. You don't need to turn it up.
Well, I wouldn't mind, actually, because I had got the wrong impression. I had thought it, rather oddly, that the MOD themselves filled in the form.
Yes, they did at the time. I think I said this morning that that's what's changed now, that apparently I'm told on instruction they now send somebody a secure link where they download
Oh,
it.
I see.
Yeah.
So at the time, it was actually an MOD official who'd get the online form, put in the data on behalf of the applicant, and the applicant wouldn't even necessarily see.
I think they would see it.
Ah.
I mean, we've got the witness.
Well, well, you
statement
better see what it does
Maybe
say.
that I misunderstood it. But it's page 307 where she deals with this. So the judge at first instance, Mrs Justice Laing, fastened particularly on paragraph 9, ARAP is not principally an immigration.
Wait, I haven't got that far yet.
I'm so sorry, my lord.
307 supplementary.
Yes, that is not a statement of fact. That is an expression of her desperate view.
Yes, well that's right, and it was only really to set the context to
This
an
is-
explanation.
Sorry, the two of you having a debate about a passage I haven't yet found. Where is it?
Page 307.
Yeah.
So she starts
Which
off.
page is? Not
Oh,
principally
I'm so sorry.
immigration.
This is the supplementary bundle.
Yes,
not
I've got the page now.
the- Okay.
Top of the page, paragraph 9. Arab's not principally an immigration policy. Well, that's
Yeah.
Oh.
arguable. Is that the same page?
It is the same page.
Yes, okay.
But she goes on to try and explain what we looked at this morning by reference to the guidance, that there are different sorts of...
Paragraph 12 is the facts, what happened, who did what to whom, and 12 says it's the MOD who taps out the digits on the laptop that fills out the thing.
Let me. Sorry,
Precisely.
If just give me 1 second, I'll actually read it.
It's 11, 12 and 13, I think.
Well, it's oblique. This is exactly what I read. As my lord says, that must mean the least that means is they type it all in. you might think they then send it off and say, can you sign here? We've completed the form for you. But maybe they wouldn't. Maybe they would just do it, maybe they just send it straight in.
I don't know, but what I do know is that that was the evidence before the judge at first instance, which I read as being there is a specific visa application form which is filled in by the MOD only in respect of applicants who they accept are
Yes,
eligible.
well, I think, no, I'm sure that's what it says. And you've now shown us that form. And really all we're now left uncertain about is you tell me that now the MOD don't. But that wasn't the evidence. The MOD don't fill it in themselves. They send it off for the person to fill in.
Yes, because I was told on instructions when I was given the form this morning that what happens now is there is a secure link which is emailed to applicants who are found to be eligible, and they now complete the form
But oddly enough, the only form prior to this introduction of secure link, the only form, the only document that anyone could get access to claim under the rules as a relevant Afghan, would be a piece of paper, an online piece of paper headed the ARAP application form. They would never see a second screen saying visa application form according to this. That would have only been seen. So that then does go back to beg the question, if the only physical thing that you see on the screen is a documented ARAP application form, and that's the only thing the applicant fills out, why isn't that the form?
One answer, I suppose, which I understood from what you were saying earlier, is all this is based on a passage in the guidance, which is a hyperlink for what is an application form. If you click on that, you will never get to this VAF form or to indeed to the ARAP application form.
Yeah, that's right. So we say that the LOTR guidance in context is plainly talking about the leave to enter application form, visa application form for visa nationals, and that the ARAP scheme doesn't work that way. The form
Well,
that's...
we have these. Yeah. Anything else?
No. Can I just turn briefly? No.
We will just go out for a minute or two and...
Before you
yeah.
arrived, I've just got the Mrs. Justice Hill documents, which
What have you got,
the
sorry?
the completion of the JZ material, which Miss Giovanetti
Oh,
had.
well, while we're out, the Utter can put it on our bench.
Well, this is your own material, the judgment in JZ, and the Part 18 response. Sorry, I've got that.
Part 18 was not...
No, I mean, sorry, you weren't in it.
Yeah.
No, I'm so sorry. I'm so sorry. I've got a bit of a because you were in JZ in the other. It's Ed Brown. Sorry, it's the Part 18 response that I referred to, and the judgment which refers to that. What ARAP? Who were the ARAP judges and who were not? I'm so sorry. I've got that. There. Here's another judgment. I suppress. I did. You gave me 6. What have I done with them? That's leaving. She does. I gave you 2. Yeah, I did give them 2. Sorry, I've got leaving, which is they didn't want leaving. I haven't got any of my own now. Sorry, I think I gave you 2. Maybe it's very small. Did I give you 2?
Yes, you did.
Yes.
So this is a response. Charge after ordered us. These just a summary of judges.
Right. Our provisional plan is to sit again at 2 o'clock tomorrow with a view to giving you at least a decision, hopefully at least a decision with summary reasons, full reasons to follow, and just possibly a full oral judgment. However, we reserve the right, because this requires careful thought and we may simply not have enough time, either to get you a message in the course of the morning saying not going to be possible, judgment reserved in the usual way, we appreciate the urgency, but most importantly to get it right. Alternatively, to say 3 or 3:30 instead of 2. Let's see how we go. I hope at least I'll see you both tomorrow, or it certainly won't be necessary for all counsel to attend.
Okay. Ms. Masood tells me that she has a hearing at 2 o'clock tomorrow afternoon. I was due to be travelling abroad on Tuesday this week, and I put it back until tonight because of this hearing coming in. I think I'm going to have some difficulty in trying to move it again. I will do my best. But,
well, I think, look, from our point of view, we will not, substantive decisions won't, substantive submissions will not be required. You'll just have to sit and listen to what happens, and any consequentials to be dealt with on another occasion. So if the worst comes to the worst and we have to have client counsel without an involvement, or perhaps as a halfway house Mr. Brown, if he is then free, he won't be. Well, there's a large treasury panel. We can have somebody who will have been given a minimum briefing. That I have to say is suboptimal, because although we won't be doing elaborate consequentials, it's possible that some tricky point will have arisen that we want informed help on. But we will manage. It would be delightful to see you, but I don't want to.
I don't want to be unkind, but if you were going abroad, couldn't we beam you in? We've all got technology now.
I was just wondering about that. I'd be more than happy to be beamed in if the court wouldn't mind my.
No, that's a very good point. That's a very good point. I think it would be better to have you. Miss Masood's commitment is a professional one, so you can't be beamed in. We will look into that. Most of these courts are not. I think this one. Actually, no, this one has. I forgot what it's called now. Anyway, you can be beamed in. Is the talk. CPM.
I mean, I'll make arrangements to make sure I'm somewhere in an appropriate location, which is quiet and
You won't have to bring away or take your wig and gown with you wherever it is.
Thank you.
But some sort of formal dress would be appreciated.
My lord, I similarly put back my holiday somewhat some days. It's not quite as glamorous as Miss Giovanetti's, because mine is only a long train to North Wales tonight.
That sounds lovely.
So I have got that in 2 hours. I could be similarly available on CVP, but
well, I think frankly, I am a little bit concerned. You know, in the pure case, you just hear what we have to say and consequentials follow. But some questions might arise, and we would much rather have counsel who can deal with them. And you will make a selection of your juniors.
Oh yes, well, Miss Savage is available. So if Miss Savage can appear instead of myself, then that would be who's, as you know, leading in AZ and been through all these cases, and maybe one of the juniors.
Well, that's all up to you, though. I think, frankly, we can get into this. If we are in a situation where the Secretary of State is paying costs, I don't think she wants to pay for a bevy of juniors merely to sit and listen. No. We may not be in that situation.
Well, I mean, I'll leave it with Miss Savage unless on indication.
I think that would be appropriate. Very well. Hopefully until tomorrow, but watch this space.
Thank you very much.
sure that we didn't do that. But actually,
Yeah.
sorry, I was trying to dodge that.
No, no, no.